ahead of those remarks. Joining us is former assistant U.S. attorney and Fox News contributor Andy McCarthy, George Washington University law professor and Fox News contributor Jonathan Turley, and former federal prosecutor Katie Cherkasky. Welcome to all of you. Andy, I'll start with you first as we do await the former president's remarks here. What do you believe is the strategy now with this cross-examination that is happening in that courtroom?
Well, evidently what they're trying to underscore, based on the reporting we're hearing, is that these agreements, these non-disclosure agreements, are legal. They're a staple of civil settlements in the United States. They go on all the time, and they're not criminal. And they will build from that to the ultimate argument that not only are they not criminal, Trump actually isn't charged with them in the indictment.
Interesting. Jonathan, when the former president emerges from that courtroom, I can only imagine what he'll have to say. But at this point, based on what we've heard come out of that courtroom, do you believe he'll look at this as a good day or a bad day?
I think you should look at it as a good day. If this is what they thought was their strongest start, this is a particularly anemic case. I mean, Pecker described how he asked Trump about the reimbursement of Cohen, and Trump said, I don't know anything about that. But more importantly, you now have the defense pointing out that he did the same thing for other celebrities. The point is that Trump was and is a celebrity. He had a hit show on television, and that was really good for the magazine. And Pecker himself said, I had a couple of different motivations here because this is what my readers wanted as well. None of that makes a particularly good case for anything criminal, but what is still missing is the fact that he just described doing the same thing for celebrities because there's nothing illegal in this. There's nothing illegal in having an NDA. You can object to it. You can not like the underlying story, but it's not a campaign contribution, and the federal government itself made that clear.
Katie?
I definitely agree that the first witness should definitely be your strongest witness, and Pecker's testimony did nothing to prove this case beyond a reasonable doubt. In fact, he even said that he assumed that Trump wanted the stories killed for purposes of his campaign, but he didn't have any direct evidence of that. And an assumption is a far cry from beyond a reasonable doubt proof that that was the sole motivation behind these very lawful agreements. So certainly, I don't know what kind of ground they gained with him, aside from the fact of establishing that there was many conversations with Michael Cohen that seemed to be coordinating this on behalf of Trump. And again, we don't know if Trump was aware of what Cohen was relaying and claiming that Trump knew. That's certainly something that's very much up for debate.
All right, Andy, I want to take our viewers and listeners through something that just came to us out of the courtroom and get your response to it as the Pecker testimony is ongoing at this hour. When it comes to, and this is the cross-examination that is happening, this August 2015 meeting, in 2023, Pecker testified the wrong date of the meeting, and prosecutors had to correct him, okay? Just reading this verbatim as it's coming out of the courtroom to us. Beauvais, the Trump attorney that is conducting the cross-examination right now is pushing Pecker to make him question his memory and different series of events. That Trump lawyer is asking when the most recent meeting Pecker had with prosecutors. Pecker said 2 to 3 weeks ago. Pecker said he had probably 5 meetings total with prosecutors. December 2023, February 2024, he seemed flustered and can't remember specifics, saying, I don't have my calendar in front of me. The Trump attorney then said it's hard to remember the dates of to the Trump attorney, he said it's hard to remember the dates of these things, even when they happened just a few months ago. Your takeaway from that exchange, Andy?
Well, it's a pretty standard line of cross-examination, Sandra, where, once the witness is given a version of events that's helpful to the government, or at least that the state believes is helpful, you poke holes in it as defense counsel by showing that the witness isn't as sure, perhaps, as he seemed on direct examination, that the memory isn't as good, maybe the credibility isn't as high as you might have suspected. The thing I'd have some hesitance about here is I actually think Pecker, on balance, is a really good witness for Trump. He's clearly not a hostile witness, And you need to make some points about his memory. Maybe that helps something you want to say at the end of the case in summation to the jury. That's fine. But I would not cross the line and turn him into a hostile witness or get his backup, because I think he's more inclined to help Trump than hurt him.
You agree with that, Jonathan?
I absolutely agree with that. I think Andy's right on. Look, this guy has a gun to his head. He has an agreement that he signed. He doesn't want to be there. You don't want to give him a motivation here. But I think that they're scoring points right now, which also goes to what's going to happen in 18 minutes. There is a danger to sort of caging Trump in that courtroom, not able to speak. I think the other side is hoping that he will come out and vent. But what we're seeing in Pecker is how weak this case is. It's almost incomprehensible. So the president needs not to rehabilitate their case or give them anything with statements made outside that courtroom. This case is collapsing on its own weight. That also means that the president himself should not take the stand in this case. It is such a weak case that he would be given the prosecutors a possible opportunity that they would not otherwise have.
Katie, perhaps that's where we end things here. That question to you, do you agree with Jonathan that at this point, with that big decision before him, that the former president should not take the stand in his own defense?
I do agree that it would be very risky for him with the Sandoval rulings allowing in all of these other findings in the other civil cases. And so it would simply just attack his credibility in a way that's not necessary and open him up in a way that really isn't needed for the defense at this point, because the case is very weak. It's obvious why Alvin Bragg originally didn't think this case should be the first case to go, but for practical matters, it was the only one that could proceed. And it's a real risk for them at this point, because it's not looking good. It's not shaping up to really be a clear example of any criminal conduct. It's more confusing by the day.
Well, we will continue to lean on any updates that come out of that courtroom. Likely we will have court wrapping for the day shortly. And the former president, his team said earlier that he is expected to emerge from the courtroom and speak to the cameras. And we will have that for our viewers live. Thanks to all three of you for joining us.
Thank you.
Thank you.
Hi, everyone. I'm Brian Kilmeade. I want you to do me a favor. I want you to click to subscribe to the Fox News YouTube page. This is the only way that I know for sure that you're not going to miss any great commentary, any great news bites, any great interviews coming your way on Fox. You can get it all here on YouTube. So subscribe right now.